Hey gang, this is Ben with Bond Law, and in today's weighted walk, I'm going to be breaking down the U.S. Patent and Trademark Office's refusal of the owners of what is now called the Utah Hockey Club, their trademark registration application for Utah YETIS. Have a couple items I want to cover regarding the refusal. The idea for this video came from an article I stumbled across on arizonasports.com, which said that the trademark registration application for Utah YETIS had been denied. And so that brings us to takeaway number one regarding the refusal, and that is that what was issued by the USPTO was what's known as a non-final office action. Okay, it was not a final office action. It's effectively the government is telling the ownership group of the Utah Hockey Club, namely their legal counsel, that we've got some problems with your application, and so for right now, it is being refused. You still have the opportunity to respond to the issues raised in the refusal. And so while office actions, non-final or otherwise, are never good when you're applying for trademark registration with the USPTO, this is not the end of the world. Hockey fans up there in Utah, your team will still get the opportunity to respond to the USPTO. Okay, second takeaway. This was what we in the business call a 2D, also known as a likelihood of consumer confusion or likelihood of confusion refusal. It is by far the most common reason why people get their trademark applications refused. Well, what does that mean, Ben? Essentially, a 2D refusal is basically the government saying that the mark that you are applying for is either the same as or confusingly similar to an existing registration. So the general rule you want to think about, if your trademark sounds the same, if it looks the same, if it means the same thing, perhaps there's an existing registration in a foreign language, or has the same general, what they call commercial impression, then if there's an existing registration out there, that's almost certainly going to be a no-go, and at best is going to put you on the business end of a non-final office action, and ultimately maybe even a final office action, as the Utah Hockey Club is discovering. So that's point number two. But here again, for those of you hockey fans up there in the Beehive State, it's a little bit premature to remove all the sharp objects from your house, because here's where we get to point number three, is that the USPTO's refusal applies to the application in class 25, okay, not class 41. All right, so let's back up here and break some of that down here. When you apply for trademark registration, what we're talking about today here at the federal level, not only do you have to have obviously your trademark or your mark, but you also need to designate in the application what classes of goods and services you are planning to or use that particular trademark with. If you think of all of the various goods and services in the universe that you could potentially sell, well, those are broken down into classes from 1 to, I think it's 44. Okay, most of the goods are in classes 1 through 30 something, or really early 40 something, whereas services are, I'm gonna say it starts at about 41 and goes all the way to 44. So obviously goods understandably predominate. Okay, so moving back here to what we were talking about. Utah Hockey Club ownership applied in class 25. Okay, 25 is basically clothing or apparel. Okay, and they also applied in a second class for class 41, which is a service, and they applied for it. I think their description was hockey exhibitions or professional hockey exhibitions, which is understandable because that's the whole point of registering and branding yourself under that name as a hockey club. So by applying for a given class, in this case 25 and 41, you as the applicant are basically telling the U.S. government, hey, we are applying for our trademark in order to have basically like a mini monopoly, okay, to use that trademark or logo, or you have a little mini monopoly in that particular class, that particular silo, or that vertical. All right, so now that we've cleared that up, basically in this non-final office action, the USPTO made it very clear that, you know, our problems with your application apply strictly to your application in class 25, again, which is clothing, apparel, not class 41. So the point I want you to take away from this, particularly those of you up in Utah who are really hoping that this is the name of your professional hockey franchise, is that all is not lost. Even though the team will almost certainly be refused on a permanent basis their application in class 25, there's a very, very good chance that they still will obtain registration in class 41 for hockey exhibitions, or however they end up describing those goods and services in order to comply with what the USPTO examiner wants from them. Okay, so that's the good news. The bad news is, well, your professional sports franchise, you know, selling jerseys, sweaters, you know, just general merch that can be worn. You know, that's kind of what you do, right? That's where a lot of the juice is, and the concessions are, and the reason why these franchises, in part, are so valuable to begin with. So having the name registered in order to be able to conduct hockey games is not nearly as much of a win, I guess, as being able to have them to be able to license and sell official merchandise. All right, so I'm going to get into more about why exactly Utah YETIS was refused in class 25 in the second half of this video, which we're about to enter into.